Just briefly, most of you have probably already figured out where your company falls in this whole array of coverage. The smallest employers with less than 5 employees and net income of less than $1 million can provide unpaid sick leave, 40 hours a year, or capped at 40 hours a year, that is. If you have more than 5 employees or sales over net income over $1 million, then you are going to be providing paid sick leave. And just to be clear, there's no government program to reimburse for this money like there was for the FFCRA in the event that it's been something you've dealt with. Here's a question that I'm going to get to in a minute, but I will answer the easy question first. Do I only count New York employees or all employees? It seems like it's clear that you only count New York employees. So if you have employees in other states, they will not count. We're going to address that in a couple of ways going forward, though. The trickier question comes in, and we'll get to this on the next slide, is how many employees do you have in New York? If you are close to one of the thresholds, under 100 employees with income over $1 million or income of any level and more than 5 employees, you have to give 40 hours a year. For the employees with 100 or employers with 100 or more employees, you have to give 56 hours per year. So if you're really big, it's not a problem. You know where you fall. But if you happen to be right on the border of 5 and have sales under $1 million or net income under $1 million, or the border of 100, then the next slide becomes potentially relevant. So how do you count employees? Well, there was a specific clarification that if you have multiple work sites within the state of New York, then you aggregate those. So if you have 5 employees in Buffalo and 5 employees in Syracuse and 5 employees in New York City, then you have 15 employees. Again, I don't think you're covered if you're outside of the state of New York, except for a wrinkle that will come back up again, and that is for employees who work in multiple states. So once the employee comes into New York and performs work, then the guidance does suggest that for that time they accrue leave. So that's complexity we'll talk about in a little more detail, but apparently they would then count, which can be a factor in this really confounding situation that the law says you count employees in any calendar year, meaning the 12-month period from January 1st through December 31st. Note that for the net income purposes, they reference the previous tax year. So it seems arguable that if you have 100 employees total across the year, then throughout that year, your employees can accrue and use up to 56 hours versus 40, which raises the interesting conundrum of what happens if we have 90 employees for most of the year, but then at the end of the year, business really picks up and we end up hiring 15 more people. Now what do we do? Arguably, I suppose that you have to then retroactively give your employees more sick leave, but how could you now let them retroactively use sick leave that they didn't already have? I think it's pretty surprising that the state did not address that in their guidance. It may be because there's frankly no logical way to interpret the statute.